Welcome to Servicing Made Simple, where we are trying to take a little bit of the complexity out of compliance with mortgage servicing. My name is Hunter, and today I am joined with a couple of compliance nerds. We've got Taylor Hildenbrand, who leads up business development and industry relations. You probably know his face. And we have our guy in charge CEO, Tracy Yates. So today we want to talk about the latest issue 25 of the CFPB's Supervisory Highlights. This is from fall 2021, and these are highlights in which the CFPB has found certain areas where servicers are not in compliance with Regulation Z, Regulation X, and then some UDAP principles, that unfair, deceptive acts or practices, which is prohibited by the CFPA. And those UDAP principles are anything that's unfair when it causes or is likely to cause substantial injury, the injury is not reasonably avoided by consumers, and the injury is substantial, and it's not outweighed by countervailing benefits to consumers or to competition. So today we have 7 highlights that we're going to walk through. And really these are the CFPB's agenda materialized. We've been talking a lot about the CFPB beefing up enforcement in some areas. They are better equipped and fully staffed to kind of play out that enforcement. And so we're really getting a good look kind of on the inside of what even might be coming in the next wave of enforcement in certain areas that are really highlighted here in these highlights. And we just want all of our clients, servicers, to be prepared, to be doing things the right way. And so we advise even that some areas in which you have been doing things a certain way for a long period of time, it might start being the time to reconsider those things, reconsider those practices. And maybe you've even thought that those are the right ways to do things, or the most efficient ways to do things. And we're here to share with you insights in which the CFPB thinks that these practices should be done. And so, Taylor, why don't you go ahead and let's start walking through these 7 highlights and just sharing briefly kind of what they are and what people should be aware of.
Thanks, Hunter. Well, and what people should be aware of is these supervisory highlights, like you mentioned, come out pretty frequently, 2 to 3 times a year. And we haven't seen a UDAP identified in these in the last 3 years. So those are pretty infrequent touch points or data points for us to see what's in the mind of CFPB. And the scope of this thing's from January to June. So we're really not seeing the full mind, I guess you could say, of the new team of enforcement professionals that you had mentioned. And just looking at it, I mean, 4 of the 7 findings are those UDAPs, and then there's 3 kind of black and white, obvious, really rinse, wash, repeat findings that we've seen before. So it really comes down to fees and timelines, if you ask me. This first one that we're talking about is everyone's least favorite topic of late charges. And I know, Tracy, we've talked about this a lot in some of our findings, but specific to CARES Act, what they're saying, or I guess identifying more, is that these late charges were illegal because it charged them harm. And after a forbearance was set up, there wasn't that step to retroactively cancel those late charges. And what are your thoughts on that first one, just from charging those illegal fees?
Yeah, Taylor, what we're seeing is basically servicers are charging a late charge and then putting a borrower up on a COVID relief plan of some sort, but then the borrower, those late charges are now being waived retroactively after the plan's being established. So once a plan's been put in place, then it's really not been a problem. It's really that late charge that happens right before the plan gets established. So my advice is basically make sure that you're waiving those fees for the borrowers, late charges in particular, when they are on a plan, and have someone evaluate that. And if you collected money from a borrower that was on a plan, then refund it to them.
Well, and even in the supervisory highlights, what they mentioned on that first one was that some servicers identified systemic errors. So even if you're saying, oh, well, this is just a loan level issue and we fixed that one loan. There might still be some under the hood work that needs to be done. And so never neglect those, quote, one-off findings from really identifying those system level issues. And this second one is probably in that same category of, underlying system errors. And it kind of falls in that same bucket I was talking about earlier of fees. So we were talking about late charges. And this next one is really those NSF fees that are charged to borrowers. And this has an interesting wrinkle to it because what they're saying is, even though your ACH agreement with a borrower might permit you to charge them a late fee if the account's closed and that you would keep trying to debit that same account, what they identified was that where a prearranged agreement was in place, but the account was closed, servicers continued drawing on those accounts, racking up a bunch of NSF fees, and the CFPB basically just said, what the heck? You can't do that. What they're kind of interpreting around that would be to say that the borrower couldn't avoid the injury and that servicers should not, there's that lovely should word, continue to attempt those transaction attempts even if your agreement allows you to do that. So they're really trying to protect the borrower in that account closure NSF fee situation, Tracy. And I know as a CPA, I'm sure you have some thoughts on this in particular, but what should servicers be mindful of to avoid that, really the pre-authorization ACH agreement and those NSF fees that CFPB talked about?
As a practical matter, I think, Taylor, yes, what I would recommend is servicers go back and really just review their EFT agreements and make sure that you're doing what you said that you were going to do. And in many cases, those agreements do say that you will cancel the EFTs when you have an account that is closed. If that's the case, then make sure that's what you're doing. And then lastly, I would say to go back and reverse or refund those charges for closed accounts if you charge them more than once. So maybe you charge them the first time and the account was closed, that's fine. Then you hit it again, you charge them again. Just don't do that. And if you did, refund it or reverse the charges if you've not collected it. Taylor, this next item is really similar to the late charge issue, so I'll just take that one as well. Basically, the CFPB is identifying charges to consumers in unauthorized amounts is kind of basically their terminology. But basically what's happening is, at least in their representation, is that servicers are charging amounts to borrowers that they did not incur specifically for things like inspection fees. So maybe the servicer got charged $5, but they are charging to the borrower $6 or $7. And CFPB is saying that's a problem. So our thoughts there are basically just to make sure that any fees that are being charged to a borrower are either disclosed either at year end or in your monthly statements, that you're going to have those kinds of fees, and then stick with the amount that you have disclosed. And then if there are fees that you've incurred on the borrower's behalf that are being passed on to that borrower, just make sure that those are justified and they are supported and they are accurate and consistent with the amounts that you've incurred as a servicer.
So the fourth and final UDAP that the CFPB highlighted in this iteration of their supervisory highlights was one that should be no surprise to anyone if you're keeping up with this, and it's the CFPB saying your website and the rules don't match up. And I guess there's really no credit for the rules changing every 5 seconds over here, but at the end of the day, what they're really looking for is that the online information, either through the borrower portal or on the publicly available website, that information is consistent and accurate to the requirements and the rules at the time. So what we've seen, and really what we would recommend here, Tracy, you can jump in if you disagree, but what we would recommend is that you have someone that has a servicing compliance brain involved in the web development process. So oftentimes if it's just either a bank level compliance person or really no level of compliance oversight before you push information out, even the slightest difference can be misconstrued. I mean, you look at the difference between must versus should and 3 to 6 months or minimum of 6 months. Those words can mean different things to different people. And if you're looking at an entity that's saying this was deceptive because you had false information, I think it's really important to make sure that a servicing compliance person is part of that approval process and really getting those routine information updates, getting a sign-off process built within that.
Taylor, I totally agree with your comments. This next item really relates to completing loss mit applications within 30 days. I think most everyone is really achieving that objective, at least in the cases that we have seen. And it's really basic stuff. You just have to ensure that you've got adequate staffing. You must ensure you have exception reporting to identify loans that are falling out of the CFPB deadlines and timelines. And frankly, I think their patience is just up on this issue. We've had time to figure it out as an industry, and I think now we'll start to see some enforcement around this rule that's really been out there for quite some time.
And I'm going to skip around a little bit because I know what you just were talking about, Tracy, with the timeline delays. Really, that seventh item that the CFPB highlighted, which was failing to automatically terminate PMI once it reaches that 78%. I mean, I'm sure everyone has some standard exception reporting around that. And what I thought was interesting is the CFPB is still picking that up where servicers aren't capturing that. And maybe the root cause is still human error. But that's still something that needs exception reporting and some level of QA, QC to make sure that once that 78% LTV is reached, that and even if you aren't able to automate that process, that you still have those humans in there doing that on time. So really similar to that loss mit issue where you just need to get your folks and your reports in there on time. And with this last one, Tracy, I want to get your thoughts on it because the sixth finding is just a black and white violation of Reg Z, where your partial payment application process, they noted where some servicers were having some issues with that, where you post your normal payment and you've got some excess funds. Okay, what do we do with that? They noted where it didn't go into suspense or they didn't hold it as you should. They didn't return the partial payment to the borrower. And there was just some issues that servicers were having. I think it's kind of hard to follow, but it seems like what the servicer did in this situation is they applied it to a true escrow account rather than handling it in accordance with Reg Z. So I'd love to get your thoughts, Tracy, on what servicers can do to kind of get ahead of that, even if they're not seeing those partial payment application issues, and maybe where those bodies might be buried in their own portfolio or suspense buckets.
Yeah, Taylor. So Reg Z does require that servicers either disclose to the consumer the total amount of funds being held on some sort of periodic statement, and if there's sufficient funds to post that payment, that the payment actually gets posted. So I'm not really sure, like you said, what issues or where this really came from, whether it's one or the other or both of these matters, but I think the resolution is relatively simple. One, we have to be working those unapplied funds buckets regularly and making sure that borrower money that can go out is going out and getting posted where possible and being returned to the borrower where we don't really know what to do with it and we don't have the proper instructions. So really just borrower communication, I think, is the key to this, and really making sure that we've got adequate management reporting and oversight to ensure that we're following our own policies and procedures.
Thanks so much, Tracy and Taylor, for that great information, rolling through those 7 supervisory highlights from the CFPB. And we hope this was helpful for all of you guys out there listening. This is something that we've been flashing red lights about for quite a while now. CFPB enforcement beefing up the agency, hiring on more and more people. And this isn't something that we want to just scare people about or speak flippantly about. This is something that we want to help you with. And so if there's any way that we can help you with any of these items, then let us know. You can email Heather at heather@bridgerm.com or visit us online at bridgerm.com. And if one of these 7 items didn't directly relate to you and what you do for your organization, but you know peers who might be affected by this, then feel free to shoot this to them. We want to help as many people as possible. And from all of us at Bridge, Merry Christmas!